An Albanian criminal who originally entered the UK illegally had his deportation stopped by a tribunal because his child didn't like the taste of chicken nuggets abroad. Now, I don't like, and I'm not quick to criticise the tribunals of this country, but this is probably one of the most ridiculous decisions I've ever seen. So I'll discuss it with you in this video because it's absolutely true. Somebody joked that it should be an April Fool's joke. Surely it's an April Fool's joke, somebody said on X. Well, it's not. It's absolutely true. And first of all, if you do me the favour of subscribing to this channel, I'd be really grateful because I depend on you to do that. Nothing else will make my channel grow than you. So thank you very much. So let's take a look at the decision. Now, just to be clear, this is the decision of the upper tribunal, which found that reasoning regarding the chicken nuggets to be irrational or perverse and thus reverted it back to the first tier tribunal to be heard by a different judge. So let's take a look at the facts here. So this was an Albanian-born individual who in 2001 entered the UK illegally as an unaccompanied minor. 2 days later, he made an asylum claim on the basis of political persecution. He stated falsely that he'd been born in the former Yugoslavia in 1986, and it also appears that he used a false name. His asylum claim was refused in September 2001, with the Secretary of State not being satisfied that he got a well-founded fear of persecution, and thus he sought to appeal, but that process was withdrawn in 2003. For reasons I'm not aware of, because they're not stated here, he was then granted exceptional leave to remain on the 8th of September 2005 and indefinite leave to remain on the 26th of September 2005. He was then naturalised on the 6th of December in 2007. He met his partner in 2006, who was a naturalised British citizen. They are still together. They share 2 children, referred to here as B and C. And it was common ground that child C, had additional needs. However, in 2017, this chap was then sentenced to 2 years imprisonment for the offence of acquisition of, use or possession of criminal property. He'd been stopped and searched while in the possession of £300,000 in cash, which were the proceeds of crime. This conviction then led to the deprivation and revocation team informing him that a deprivation of citizenship process had commenced, and in July 2021 he was deprived of his UK citizenship on the basis that it had been acquired through deception. The deprivation order was served on his legal representatives. He sought judicial review of the decision and the permission was refused in October 2021. He then appealed the refusal of a human rights claim following the deportation order, and then this came before a judge in June 2024. This judge heard oral evidence from both him and his partner, and one of the children wrote a letter in support of him. And then they conducted what they call a stay-and-go analysis. So what happens if one party or other stays here or goes, and the impact on those individuals? The judge concluded that it would not be unduly harsh for his partner either to follow him to Albania or remain in the UK without him. In particular, the judge said that his partner speaks Albanian, has a family in Albania, and she would be resilient and capable enough to remain in the UK without him. The judge also considered that it would not be unduly harsh for child B to go to Albania. However, then we come to the point about child C, which is ultimately what halted this man's deportation. Bearing in mind he was a convicted criminal and they'd revoked his citizenship and therefore wanted to deport him. Now, this said that the judge decided that both stay and go scenarios would be unduly harsh for C. So to unravel that a little bit, the stay principle would be if the child were to stay here but he were to go back to Albania by be deported, then that would be unduly harsh on the child. Alternatively, the go scenario, if the child were to go with him to Albania, that would be unduly harsh for the child. And accordingly, the original judge allowed this appeal on human rights grounds, the right to respect for family life, and it was this part of the decision only that this appeal turns, the one that I'm reading right now, this upper tier tribunal decision. So the Home Office appealed that decision solely on that one principle that halted this deportation, which was in relation to child C. And that is the bit that I find absolutely and utterly ridiculous, with the greatest respect possible to the tribunal here. And the point of that was this, and it's detailed in paragraph 31. It says, considering the stay and go scenarios separately, we can only see in the decision a single example of why child C could not go to Albania. So considering the go scenario, the child goes with him to Albania, him being deported, the reason against that was as follows. Cited at paragraph 27 of the original decision, C will not eat the type of chicken nuggets that are available abroad. That was it. that was the only principle upon which that original decision turned. So they halted his deportation because the only reason that the child could not go with him to Albania was because he didn't like the chicken nuggets abroad. Now, with great respect to the original tribunal, I just cannot see how that is a reasonable decision. But as it turns out, the upper tribunal agreed. The upper tribunal here, at paragraph 31, said, "We are not persuaded that the addition of this sole example approaches anywhere near the level of harshness for a reasonable judge to find it to be unduly so. Were he to remain in the UK, we cannot see how any reasonable judge could find that A, the mother, who is found by the judge at 37 to be robust and capable, would be incapable of caring for C without the appellant, or that it would be unduly harsh for her to do so. So in other words, if the child were to stay in the UK, it would not be unduly harsh on her because she was robust and capable of taking care of the child if the man were deported to Albania. So the stay provision was perfectly fine, and the go provision doesn't come anywhere close to being unduly harsh because of that one sole example. So, in essence, the tribunal here said that either stay or go scenario would be perfectly fine. If the child were to stay, it's not unduly harsh on A because she was robust and capable of taking care of the child. It wouldn't be unduly harsh for her to do so. And the only reason cited that the child could not go did not come anywhere close to the level of harshness for a reasonable judge to find it unduly harsh. And thus the tribunal was invited to find that the decision in respect of this child was irrational or perverse, and to preserve the findings in respect of A and B, the other child. And the tribunal did so for the reasons given above, and it followed that the tribunal was satisfied that there was an error of law in the decision that it would be unduly harsh for the child were the appellant to be deported. And thus the notice of the decision was that there's an error of law. The decision was set aside in respect of C on the Article 8 grounds, but preserved in respect of the others. And the matter is reverted back to the first-tier tribunal to be heard by a different judge on the sole issue of whether the consequences of deportation will be unduly harsh on this child. And so one of the reasons I talked to you about decisions like this is many of these decisions you'll never even get to hear about unless they are appealed to the upper tribunal by way of example, and unless you take an interest, unless it's reported, unless news companies cover it, or unless I cover it on a channel like this and explain what has happened. But this was a single individual who entered the UK illegally in 2001, and despite whatever circumstances, it was thought just and reasonable to grant him exceptional leave to remain in September 2005, and then indefinite leave to remain in the 26th of September 2005, and then naturalised in 2007, a process that many people will understand is not a simple one to go through. So despite all of that, he was then convicted, sentenced to 2 years in prison, leading to a deprivation order and a deportation order, upon which all of these appeals turned, and round we go in this process. And thus here we are in 2005 when this decisions and reasons judgment has been issued, many years after all of this has happened. Now again, the reason I do these videos is this is but a single individual who entered the UK illegally. There are tens upon tens of thousands of people that arrive illegally in the UK every single year, and each of whom may go through this whole process, costing many thousands of pounds in legal fees, both if they receive legal aid and for the Home Office in fighting such claims. And whilst I generally like to trust that each of those cases are proceeded and adjudged fairly and according to law, cases like this do make me question how the law is applied in these sort of situations, because this one, as it was a sole example referred to here, you can read between the lines the tribunal's frustration here that there is just a single example. It says here, "We are not persuaded that the addition of this sole example approaches anywhere near the level of harshness for a reasonable judge to find it unduly so." That to me reads as a frustrated tribunal wrangling with the original decision, wondering why that was ever arrived at in the first place. Now I stress, I mean no disrespect to the original tribunal, but I just cannot see how that decision was ever made in the first place. But that is the situation we're in. If this is the case with thousands of others, this is why the UK has a problem with immigration. Now I'm not doing this video to stir up any tensions and confrontations with anybody. This is a legal commentary on exactly what is happening. These are proper legal decisions that are happening, and without someone such as myself to help you understand what's going on, how are you then the individual to make an informed decision for whom you vote at the next general election? Now that is many years away, but it's things like this that you need to decide what governments have done in the last years and what governments are promising to do in future years and who you will vote for. So let me know what you think about this, politely and respectfully in the comments, please. Remember to like the video and subscribe to the channel and hit all the buttons and the notification bell. That really does help YouTube to spread my videos to a wider audience. Really grateful for that. And as always, thank you for watching.